Good day. This is Clint and V. Austero, the Innovation and Technology Support Office, ITSO Manager of Silliman University. Today, we will look into or discuss on the topic intellectual property and intellectual property rights. IP, more specifically intellectual property rights, IPRs, is very important, especially in the academia. And for faculty, staff, students, and administration to know because it protects their ideas and inventions and even written works. It gives faculty and students ease of mind that their hard work will not be exploited from other people. So in today's topic, we will try to answer these following questions. What is intellectual property? What is intellectual property rights? Why is IP or IPR important? What are the different kinds of IPs and what are some examples of IPs? And what is the value of IP? So to start off, let's try to answer the question, what is IP? When we say intellectual property, according to the World Intellectual Property Office, WIPO, it refers to the creation of the mind, which includes inventions, literary and artistic works, designs, and symbols, names, images used in commerce. So if you are the first to think about it and put it into writing, then it is your intellectual property. Take note that it needs to be written and documented and sometimes registered to be considered yours. And furthermore, IP is a race, so it is a first come, first served basis. To add to that, IP is also considered as your assets. So if it's your asset, it means that you can do what you want with those assets. Just like your car, you can sell or buy or lease. Your IPs can also be sold or leased or licensed to other people. So the next question is, how do we protect our IPs from other people who may benefited from our hard work and ingenuity? So this is where intellectual property rights comes in. By definition, from the World Trade Organization, WTO, intellectual property rights are the rights given to a person over the creation of their minds. So this is the intellectual property. They usually give the creator an exclusive right over the use of her creation for a certain period. To put it in simpler terms, IPRs are your rights to do whatever you want with your work and prevent other people from exploiting it. So why is IP important? So why do we need to know IPs? So IPs are important because it makes innovation possible. So based on the PwC information, we can see that technology is the leading innovation here in the Philippines. With IP, individuals and institutions are given the freedom to conduct research, design, and develop without the threat of anybody stealing and benefiting from their creativeness. IP rights incentivize entrepreneurs to keep pushing for new advances in the face of adversity. IP rights facilitate the free flow of information by sharing protected know-how critical to the original. In turn, this process leads to new innovation and improvement on the existing one. So also, you can see in the next slide that the Philippines is growing in its Global Innovation Index. In 2018, we are ranked 73, and now we are ranked 54 in 2019. We can see that in this graph, the country is pushing into innovation. Now, the next one. The importance of IP is to ensure quality. We know that if there are uh, intellectual property rights, there are mechanisms to protect your creation. Therefore, substandard duplicates and imitations are prohibited. It prevents pirates and copyright products to be produced, manufactured, and even marketed. Another important thing about IP is that IP improves our daily lives because IP is everywhere. So everything from your chair to the table to the coffee mug and so on, somebody has made and thought about it, and therefore it is their intellectual property. With the new products which improves our productivities are constantly developed. Examples of this are your phones, transportations, and things in your house. The next one is IP drives economic growth. According to studies, the level and structure of innovation should not be ignored because it plays an imperative role in stimulating economic growth. I will give you an example. America's IP is worth 6.6 trillion, more than the nominal GDP of any other country in the world. IP-intensive industries account for one-third or 38.2% of total US GDP. The direct and indirect economic impact of innovations are overwhelming, accounting for more than 40% of US economic growth and employment. So next one, why is IP important, is because of the previous one, IP creates and supports jobs. With IP, it fosters commercialization and creates startups and business and improves companies or SMEs. In recent years in the Philippines, the spirit of entrepreneurship has started to spread. It is present on the many projects of DOST, Department of Science and Technology, DTIs, and other institutions in the country. It is also evident in the growth of our SMEs, the micro, small, and medium enterprises. At present, there are over 900,000 SMEs, representing over 90% of all Philippine enterprises and accounting for 70% of total employment. And lastly, why is IP important is because it generates breakthrough to the global challenges. With IP, especially in hard times, COVID-19, global warming, and so on, nearly all of the hundreds of products on the World Health Organization essential drug list, which are critical to saving and improving people's lives around the globe, comes from the research and development intensive pharmaceutical industry. That depends on patent protection. Patent-driven discoveries in alternative energy and green technology is currently helping and improving energy security and address climate change. So the next one is we're going to talk about what are the different kinds of intellectual properties. So, or intellectual property rights. In intellectual property rights, there are 5 common that I will talk about in this topic. Each one of these have different coverages and different rights. I have made a table that simplifies and identifies the different types of IP rights based on what is protected, how to obtain the protection, where you're going to register, and the duration of the protection. The first one is patent. If you are an inventor or an innovator, your inventions or process can be protected by law through patent. You need to first file patent in order for you to be protected. You can file your patent through IPOFIL. In IPOFIL, they have their own websites where you can submit your applications there. The duration of protection when a patent is filed will be 20 years. After that 20 years, your invention will be considered to be in the public domain. A short description of patent, if you might wondering, what's a patent? Is a government issue grant bestowing an exclusive right to an inventor over a product or process that provides any technical solutions to a problem in any field of human activity, which is new, innovative, and industrially applicable. So a good example of this are, we can see this patent information. You can see a quadcopter drone and a Bluetooth drone. So one of the files that we will be sending to IPOFIL will be a drawing of your inventions. So you can see here that what does it mean if you have seen this patent information. So it means that you cannot use, produce, manufacture, or market such invention because such invention is still patented. The IP belongs to somebody or a company. So you cannot produce a similar project or similar invention if it is still in copyright protection or patent protection. The second one is the utility model. So the utility model, or UM for short, some might call it petty patents because it's not as intensive when testing for uniqueness. So the difference between patents and utility model is you no longer need to check for inventiveness. No? So being obvious. Okay. So the same thing with patents, however, you are still going to register it to IPOFIL. So the duration of protection is 7 years from the filing date. Okay, so here we have some examples of utility patents or utility model patents. So we can have there the iPhone, the different iPhone apps, the buttons, and so on. No? The functions of which it is used. And the other one is, you can see there a utility model for Michael Jackson's shoes, where he is leaning on. So that's considered a utility model. So we will try to ask ourselves, what are the things that are not patentable or non-patentable inventions? So you have to also know this. So the first one is discovery, scientific theories, and mathematical methods. So it means that formulas that you've created, theories, and so on, hypotheses, and so on, are considered non-patentable. So you cannot patent that one. Another one is rules and methods of performing mental acts, playing games, or doing business, and programs for computers. So basically, these are some rules and regulations for a game, policies in your businesses, and programs from your computer. However, programs for computer is protected by another intellectual property, and it is protected by copyright. And we will discuss that one later when we reach the copyright intellectual property. The third non-patentable inventions, methods for treatment of humans and animals. So anything, methods, a process in treating humans or animals is non-patentable. The reason behind this is you don't want your doctor to stop operating because some processes are patented. Okay, so those are the things that are not supposedly, it's unethical. So another one is plant varieties or animal breeds. So these are discoveries. So it's non-patentable. So essential biological process for the production of plants or animals. And this provision should not apply to microorganisms and non-biological and microbiological process. Another one is provisions under this subsection shall not produce Congress to consider the enactment of laws. So laws are not patentable. Another one is aesthetic creations are considered non-patentable, but again, it is considered a industry design intellectual property rights. So it's another patent, or it's another intellectual patent coverage. So another one is anything which is contrary to public order or morality. A good example of this one is you are not, or it's not patentable to create a time bomb, okay? Because it destroys public order and morality. Okay, so those are the things that are non-patentable inventions. Now the third one, the third one is trademarks. So what is trademarks? So these are logos, symbols that represents the image of one's business. So you need to file this one again to IPOFIL so that your image or brand will not be exploited by other people. So if you are a business owner, make sure that your business title or business name or brand name is intellectually patented or intellectually protected by trademark. So you can go to the Department of Trade and Industries, and there is what we call there the satellite office in which you can register your trademarks. So trademarks, again, it is registered to IPOFIL. Does not what are tested does not duplicate existing mark. So that's what. So there should be no duplications. And the duration of such intellectual property rights or trademark is 10 years and renewable every 10 years as long as it is used. So a good example there is the trademark of Globe and Smart. So you cannot use those symbols, you cannot use those images for your own personal use, your own business. So you cannot use those logos and drawings, including the fonts and the color scheme. So you cannot follow that one. The third one, the fourth one is the copyrights. So as in the academic environment, it's very crucial to know your copyright. So what is copyright? So copyright is if you're considered yourself as an author who makes novels and books and poems, artists who take pictures, do paintings, do choreography, or even making music, and a content creator making videos and filming, then your work can be protected by copyright. The difference between this IP protection from the rest of the IP protections there is no need to file or deposit it to IPOFIL or to the National Library of the Philippines. Now, upon creation, you are entitled to protection or copyright protection. When the moment you put the lyrics to your song to a piece of paper, and when you write the first chapter of your book, or when you hit the record button on your online discussion, even at TikTok videos, you are entitled to a copyright. So what does it mean? You have the sole authority to do whatever you want with your content. Nobody should be able to make use, produce, or profit from your content without your permission. Now, you would ask yourself, how will you know who owns the content if you don't file? The short answer for this one is you need to try to show that it is your content. Make sure that when disputes comes, you have the evidence that show that you created the content and the date and time of when you create your content. You should place a timestamp, electronic signature, and so on to your documents. But for me personally, the best way to protect your intellectual property or copyrights is to deposit the document through IPOFIL and LLP. So you can go to the website of IPOFIL and you can deposit your creation there. So what is tested? Originality. So they will look into some other music, if you're looking into music, if there are other duplicates, there should be no duplicates when you are going to submit your works. And the duration of the copyrights is lifetime. As long as you are alive, therefore, your creation is still copyrighted. And even that, plus 50 years after death. A good example is that you can make use of Michael Jackson's music into your videos without permission because it's still copyrighted. You need to wait for another 50 years. It's just an estimate because it's in the US to do so. In copyright, you have to consider also that there is what we call moral rights. It allows the author or creator to take certain action to prevent protection, to preserve and protect their links with their work. And the other one is economic rights. Allow the right for owners to derive financial reward from the use of their work. Okay. The next one is what we call industrial design. So what is protected? It's the aesthetic features. How do you obtain the protection? So you still need to register. And where do you register that one? You register it to IPOFIL. So what are tested? Does not duplicate with existing design. And the duration is 5 years, renewable not more than 2 consecutive 5 years for a total of 15 years. So in order to be registered, an industrial design must be new or original creation. So the following industrial design should not be registrable if industrial design that are dictated essentially by technical and functional consideration to obtain the technical result. So basically what I'm telling you here is it's purely aesthetical features. A good example there is you can see there a wheelchair. So the wheelchair's function is to help move disabled person from one place to another. So so the aesthetic design is changed. Therefore, that design is protected by industrial design. You can see there are several chairs, and you can see there this different design of sinks. No? And it's basically they have similar function. However, the aesthetic features is different. So therefore, it is considered to be industrial design. So another one is what we call the geographical indications. So what are protected? These are products originated in an area. How to obtain the protection? So it's a registration. Where to register? Still in IPOFIL. What are tested? Products should originate in geographic area. The duration, as for now, they are still planning. In the IPOFIL, they are still looking into some policies of this. So for now, it's 10 years. So a good example there is you can see there, Cebu delights dried mango. So therefore, it comes from Cebu. So it means that it's geographically indication protected. Another one good example is peanut kisses from Bohol. So another one is trade secret. So what's trade secret? So what are protected? Of course, it's business secrets. How to obtain? You don't need to register. You don't need to do anything. Where to register? You don't need to do anything. What is tested? You don't need to do anything. It's not applicable. Duration, as long as it remains secret. A good example of this one is the formula of Coca-Cola. Another example of this one is a recipe of the chicken of KFC. In our case, Chicken Joy of Jollibee. They have their trade secret. Okay, so it's protected. So the next one, so here is a picture of a combination of different IPs. So in your cell phone, you can see there that that many intellectual properties can be applied to a gadget. Okay, so let's say, for example, a cell phone. So what are patents there? So a cell phone, you can patent the hardware or the phone, cameras, the technology itself. Okay, so it's protected through patents. Trademark, what is protected there? So the name iPhone itself, the name of the app is considered a trademark. Okay, industrial design, graphical user interface, the design of the phone itself, how does it look like, and so on. Copyrights, user manual, software images, ringtones, the program itself is considered copyrighted. And of course, we have their layout design, or we call it, which was not discussed. We have the electronic circuit design. So the microchip itself is protected by another IPs. Okay. So the last topic we are going to discuss is the value of IP. So why do we need to take care of IPs? IPs is very important to us because first and foremost, it is an asset. It has a value. So we can see here that different companies are now into more intangible assets, which are considered your IPs. So currently in 1975, they are looking at buildings, properties, and so on. Intangible assets are low, 17%, but now it is approximately 87% intangible assets. So a good example also is, if you're going to look at the other table, we can see that Coca-Cola, their capitalizations is 151 billion, and now their net tangible is 7. But as you can see, the intangibles are 144, more than half of the tangible assets. So it's now very important. As a intellectual property owner, as a teacher, you own a specific intellectual property. You can benefit it by selling those intellectual properties. You can lease those intellectual properties, and so on. So here is a good example of IPs as an asset. So I know you have heard of Jollibee buying out Mang Inasal, but what is the worth of Mang Inasal back then? So you can see their trademark is around 2 trillion worth. Is that correct? 2 billion worth of trademarks. So you can see it's much bigger compared to the to other tangible assets. So you have to be very careful with your intellectual properties because it has a value. So people who can help. So intellectual property office, you can contact them through this website. You can file, you can register through this website. So there are other discussions, topics there that you might, it might help you to understand more of the patent system. And also you can go to the National Library of the Philippines, NLP, if you are concerned with your copyrights. No? So for locally, you can contact the IPSO found in the DTI department. This is the Intellectual Property Satellite Office. And also you can contact us, the ISO office, the Innovation Technology Support Office, if you have concern with your patents, trademarks, and so on. We will advise you and manage on how to manage your intellectual properties. Okay, so that's it. In summary, IP is an asset that you own. It exists everywhere. IPs can be protected by different IPRs. Each IPR has its own scope and protection. Most IPR needs to be registered to IPOPHIL or NLP, except for copyright, since it's automatically given upon creation. And the last advice that I can give you is always be mindful of what your IPs are. So I will see you in the next topic. Thank you for listening. Goodbye.